My name is Tara Detman. This case study presentation is about how defamation was brought upon two widely talked about cases. Part 1 is New York Times versus Sullivan, and Part 2 is Gertz versus Welch. First, what is defamation? Defamation is any statement or action that causes harm to the person's reputation. Defamation is usually done in one of two different ways. 1. Any harmful statement is done in writing and is published is called libel. 2. Any harming statement that is verbal is called slander. Part 1, New York Times versus Sullivan, Montgomery, Alabama, 1964. The parties to this case is L.B. Sullivan, who is a plaintiff, one of the commissioners of Montgomery, Alabama Police, and the New York Times defendant, newspaper publisher of the advertisement Heed Their Rising Voices. L.B. Sullivan testified that he was the Montgomery Public Safety Commissioner. On March 29, 1960, when New York Times released a newspaper advertisement entitled Heed Their Rising Voices, which talks about how unfairly the students in Alabama were treated. It was alleged that the students were locked out of the dining room and were starved until they stopped protesting. The ad goes on in depth in criticizing the actions of the Montgomery police. The advertisement also talks about how the violators tormented Dr. Martin Luther King Jr. by bombing his home and how Montgomery police were making false arrests for the petty offenses that Martin Luther King committed. Sullivan felt that his reputation was ruined because he was the commissioner of the Montgomery Police Department, making him responsible for all of the police activity depicted in the advertisement. He said that when any police action was mentioned, it was reflected back on him. The element of defamation or libel was the written publication in the New York Times that portrayed how irresponsible the Montgomery police acted in regards to the crimes that were occurring in Montgomery, Alabama. Sullivan stated that the publication was false and is damaging his reputation with the community, causing irreplaceable division between relationships with other public officials, the community, and local protesters. The Supreme Court embraces the Constitution to limit a state's power to award damages for libel actions brought by public officials against critics of their official conduct. In this case, proof of actual malice is applicable. The Supreme Court ruled in favor of the New York Times. Sullivan was granted $500,000 for libel against the New York Times, and the newspaper acted with malice must acknowledge that the advertisement was inaccurate. Part 2, Gertz versus Welch, Chicago, 1974. The parties in this case are Elmer Gertz, petitioner, who is the attorney representing the Nelson family in civil litigation against police officer and new CO, and Robert Welch, the respondent, who is a magazine publisher at American Opinion, who warned his readers that a national police force was being developed that supported communism. The alleged defamatory statements about Gertz. The alleged defamatory statements about Gertz in the American Opinion article refer to him as communist frontier, a Leninist, and an architect of a frame-up, all of which are considered libel in a defamation case. Welch did not check the accuracy of his allegations toward Gertz, and managing editors of American Opinion did not verify the accuracy of Welch's story and trusted him. Instead, on introduction to the article, stated that extensive research was conducted in regards to the statement about Gertz. These allegations affected Gertz because they discredited him as a lawyer and gave the readers a different opinion about basically These allegations affected Gertz because they discredited him as a lawyer and gave his readers a different opinion about basically calling Gertz a communist supporter without actual facts that he was. These allegations affected Gertz because they discredited him as a lawyer and gave his readers a different opinion about him, basically calling Gertz a communist supporter without actual facts that he was. These allegations affected Gertz because they discredited him as a lawyer and gave the readers a different opinion, and basically called Gertz a communist supporter without actual facts that he was. This caused Gertz to have a reputation damage and is not able to gain many clients to represent. To avoid the lawsuit, I would have done extensive research about Gertz and made sure that all of my allegations were true. Having the correct information would have avoided the lawsuit. California elements of defamation is defamation which consists both libel and slander is defined by case law and statute in California. The elements of defamation claim are 1. Publication of a statement of fact. 2. The California state's defamation law. The California elements of defamation is defamation which consists of both libel and slander is defined by case law and statute in California. The elements of a defamation claim are 1. Publication of a statement of fact. 2. That is false. 3. Unprivileged. 4. Has a natural tendency to injure or which causes special damage. And 5. The defendant's fault in publishing the statement amounted to at least negligence. This case has taught me the importance of making sure that I do my research and make sure that what I publish is fact so that I cannot be sued later in a defamation. This case has taught me the importance of making sure that I do my research and make sure that what I publish is fact so that I cannot be sued later in a defamation lawsuit. I need to make sure that I protect myself and my clients. So thank you for listening to my presentation. I hope you enjoyed it. Thank you.